Hello friends, welcome to the Golden Jubilee episode of our main segment of Hammurabi, where we call the guest and guest gives us lecture on various topics. So this is the 50th, that is a Golden Jubilee episode. Further, I thank all the subscribers, all the well-wishers, because of which today Hammurabi has completed 7 years, that is 9th of July 2023. Today we have a guest, Advocate RAJIV Desai sir. He is practicing for last 20 years exclusively on the criminal side, appearing in all magistrate courts, mainly Borivali Center, Sessions Court, High Courts, and even at various other Sessions Court out of Bombay. Today we will know from him everything about ABA, as to what is ABA and the whole thing. So first, Mr. Desai, we are very much thankful for giving us the time. I would like to ask you that just tell us what is the brief history and what is this all ABA about?
Before giving you this brief history, first of all, I must congratulate you, sir, because the things you have put up for our fraternity is a wonderful and fantastic thing. I cannot express in any word. All the newcomers in this legal fraternity, as well as person like me, also have learned many things from your efforts. I must congratulate you. Nobody else have done this.
Thank you.
Heads off to you, sir. Now come to the point, sir. The concept of anticipatory bail, to my limited knowledge, was not in existence prior to 1973 in earlier code. No specific provision was there. What happened that after independence, due to political rivalry, many influential people, they used to, book the people, put them inside the prison, and they have created havoc. So the government and the Law Commission of India especially have become very serious about this issue. And they have started to work since 1961. And they have landed and end up with tremendous research, tremendous discussion, tremendous workout. The Law Commission of India in 41st report, chair under Mr. K.V. Sundaram, they have made certain suggestions. And first time people have, heard this maxim, anticipatory bail. Normally people also called it as a pre-arrest bail. Now, the purpose for bringing this particular thing on the scene by Law Commission of India was very specific, that in many cases we found people with high respect, high cadre, people with whistleblower like, they are being started to book. And book in such a manner that any person who will, against whom FIR has been lodged, the first thing is to get him arrested and put him behind the bar. Subsequently, whether bail to be granted or not will be decided by the court. And this has created havoc. So I also congratulate at this juncture, though Mr. K.V. Sundaram, I am not aware about him, but I must salute him to have shown courage and to brought this concept in the Indian statute. And in the year 1974, they are coming with these amendments. And this has been brought. Especially anticipatory bail basically is, to me, my limited knowledge, is a case of Court of Session and case of Court of High Court. And obviously, to my limited knowledge, if you consider, even under section 204 of CRPC, if you look from that point of view, you may appreciate, you may not, somebody may disagree with me. Even what magistrate is granting is anticipatory bail.
Okay.
Because in private cases, upon receiving summons from the court, that is issuance of process by the court, when person first time appear before the court, it is obligatory on his part to offer a bail to the court. So without sending that person in behind the bar, the magistrate is granting him bail, and to secure his presence for the entire trial, I think it is nothing but a second type of anticipatory bail, to my limited knowledge.
Okay.
I may be wrong. It is my perception.
Correct, correct. Sir, I want to know where can the ABA be filed?
Under section 438 of Criminal Procedure Code of present code, ABA can be filed either before Court of Session or also before High Court. But usually, High Court says that directly you are coming to the High Court. First, explore your remedy under the same provision before the Court of Session. So the flow of, all big people and their big lawyer, they like to come before High Court and to make a, media news and all. These gentlemen have approached the Honorable High Court and all. But this create a havoc for the High Courts. High Court is tremendously burdened with the various matters. Writ petitions, revision applications, appeal, bail, etc., regular bail. So first, to my limited, this thing, my liking also, to approach the Honorable Court of Session, and if you have got very good case, the session judge usually consider your case. However, it is an exceptional remedy you are asking, so your efforts will be tremendously different from the regular bail. And to establish your case, you can say on probability, everything means. So, case of Court of Session and then High Court.
Okay.
Both are having a power.
And sir, just for a clarification,
Sir.
when my session court bail is rejected
Sir.
and I go to High Court for ABA,
Yeah.
it is again a fresh ABA, not revision or appeal.
No. Not revision appeal. But you know what happened? And you have to annex the order of the session court also,
Okay.
along with your proceedings.
Okay.
I mean, you cannot go by hiding that session judge order.
Correct.
But then what happened? You can always have a liberty to deal with the what has been not been considered by the honorable session judge, what has been considered under misconception by the court of session, what went wrong and what was misunderstood by the honorable court of session. This basically opportunity you are getting when you are going before the High Court. Of course, within the parameter of generosity, within the decency, you have to put everything. But you have got an opportunity to put up your even a new ground, new ground in a new argument in view of the order passed by the Court of Sessions. Yeah.
Okay. Now, sir, I want to ask you that in which case an ABA can be filed and in which case ABA cannot be filed?
Yeah. Usually people are having a knowledge that in bailable offence you cannot file ABA. In non-bailable offence you can file ABA. Okay, fine. That is a general thing, so all right. But if any person alleged to be committed an offence under Section 3 of Atrocity Act, Scheduled Caste and Scheduled Tribes
Act.
Prevention of Atrocity Act, then ABA is not permissible, it is not been provided.
Okay.
There is a bar. So normally those people, like we are people, we challenging those FIRs before the Honorable High Court under writ jurisdiction, or rather say court quashing of FIR. And there we establish how we are wrongly been booked in the FIR, or how that section is not applicable to this. And the court grant us protection. Okay. Though anticipatory bail provision is not there, but one can do that.
Okay.
Number two, in an offense of rape, this amendment brought in year 2022 that offense of rape, where there is an accusation of committing rape on a woman below 16 years and 12 years, you are not entitled to file ABA. You are barred from file ABA.
Okay.
Yeah, this is the new prevent under section 6 of 438 of criminal procedure code.
Okay. Okay.
Yeah.
So it came by an amendment.
Yes, it came by amendment.
After Nirbhaya or before that?
No, after Nirbhaya.
After Nirbhaya.
After Nirbhaya.
Sir, till now we have seen the concept of ABA. When can it be filed? Sir, I want to know what would be the basic ingredients of an ABA. Like, that at least these 5 things, 7 things, minimum. Case wise, everybody differs, but there must be something of that sort. So, can you just enlighten us on that? That what are the basic ingredients?
Ingredients for what? Means applying
For
ABA?
drafting a bill.
Drafting a bill. Okay, fine. See, basic one has to establish in their ABA. That is, number one, ABA is always on oath. Under section 437 or 439 or under 436 of criminal procedure code, when you make an application, under 436, 437, you make an application before magistrate court. Under 439, regular bail, you have make an application before court of session and high court. You are not required to administer oath on the accused. Because accused normally remains in custody. And as per the law of India, no court in India, I am making submission, no court in India can compel an accused to administer oath. Even you will appreciate while recording the statement of accused, seeking explanation under 313 of criminal procedure code, magistrate doesn't administer the oath.
Okay.
Now this is a special relief you are seeking before arrest. So you must bind yourself on oath. Suppose tomorrow it has been disclosed and revealed that you have made false statement on oath and secured the order of anticipatory bail application, then bail will be cancelled and even the case of perjury will be started. And therefore on oath you have to make an application. Number one. Number two, while doing this, you have to first establish that you are a citizen of India and you are a permanent resident of a particular state or particular area. Normally, it changes. Suppose I am a permanent resident of Mumbai, born and brought up in Mumbai. Some FIR has been lodged against me at Madhya Pradesh. When I am going there and apply, then again I have to show the things, my any document like voting card, Aadhaar card, driving like that. I am a permanent resident and of Mumbai like that. So because this is a relief where court expect that person who will be enlarged on anticipatory bail will be available to face the trial and to face the charges. Okay. So these things you have to establish. Then we came across which kind of accusation is made against you. Now normally under anticipatory bail application people go of having make an accusation against him of committing non-bailable offence. Cognizable non-bailable offence. He is apprehending arrest. And therefore is going before the court.
Correct.
So this only thing come into two ways. Number one, either police issue him notice under section 160 of CRPC and to ask him to come to the police station. So he has got apprehension. Or even sometime police issue him notice under section 41 of criminal procedure code, various section. That is 48 hours notice. So these are the cases of apprehension of arrest. And there you have to take the one copy, maybe true copy and untrue copy, what is uncertified copy as per the case. But you have to take it from the court, first court, where police is bound to lodge the copy of the FIR within 24 hours after registration of that FIR to a concerned jurisdiction magistrate court.
Okay.
You have to make an application, give an affidavit and to secure that copy of FIR. Even our Bombay High Court, in one case, in one judgment, the Honorable Bombay High Court have stated the accused can ask copy even to the concerned police station also, and police is bound to give a copy to the copy of paper to the accused. But you know, in practical things,
It is
we found many magistrates are not following the direction and judgments of the Honorable High Court and Supreme Court. So you can't expect it from police. But it happens. However, there are cases where FIR are not been lodged.
huh.
Those are the raw areas where court cannot adjudicate your allegation and your apprehension on legality. So when you are going without FIR before the court of session or high court, when the notice issued, that is the case where person have privately make complaint in writing to the police. Police have issued notice to you, and till that date when you are making an application before the court of session or high court for anticipatory bail, FIR is not been registered. Now in those cases what you will do? Without FIR, court won't grant you bail. So even in those cases you can apply the Honorable Court of Session. That sir, I don't know whether FIR lodged against me or not. But as I have received these things, or I received call from police officer, or I have received threat from this person, I have got apprehension that I may be arrested in non-bailable offence. And therefore then court will issue notice. The police say the process of you can say inquiry is going on, because for investigation registration affair is not. So police says that yet we have not registered the FIR. In that case, what court will do? Court normally gives 72 hours notice, 48 hours notice as per the case, giving direction to the police. Before you make effect of the arrest of this accused, you must give advance notice of 72 hours or 42 hours. And this person should have a privilege or should have a liberty to approach again the court of session and anticipatory bail to seek the anticipatory bail on merit of that particular accusation and the apprehension.
Okay.
So these are the various kind of situations.
Yes.
Again, you have to make you have to apply your mind and you have to try your luck.
Okay.
Sir.
Sir, one more thing connected to this. That can a defense be put in while drafting or is it correct? It is not correct. I want to know your view on that.
Sir, the basic things, in our practice, the same thing has been seen by various advocates from different tangent. It's very difficult to bring all the intellectuals under one roof, and they carry, because these, God have created all the people very intelligent. They are having a different approach. To my limited knowledge, what you have to establish before the court. See, under ABA, you are not allowed to make submission that case has been, you are innocent, false case, and absolutely throw away the FIR. You have to establish before the court, even taking the entire FIR on the face of it, what offence has been committed by you, number 1, 2. Suppose all the ingredients of offence has been made out in FIR. And you have got different story and different documents and different evidence with you, which establish a different side of the coin. Then you can go with your anticipatory bail application, all that extra documents, extra evidence, photographs, emails, etc., whatever it may be, and to establish your case. Sir, this is not the case. It is their document, it is their email which says that I am innocent. Number 1. Further, my lord, further what happened that sometime people do extraordinary, extra enthusiasm and put all their defense in advance in ABA without securing something for future and giving open, playground for the investigation officer and the original complainant to play foul in the future and to fill in up the lacunas in their story.
Okay.
Because these lacunas can be brought in the investigation by the IO at any stage.
Correct.
And therefore, to my limited knowledge, your ABA anticipatory bail application has to be so balanced that you are putting your defense but not disclosing it entirely to the prosecution side. But you successfully argue the same defense orally before the honorable session judge or honorable high court judge,
Okay.
and to convince him. Sir, these are the probabilities that I have not committed this offense. These are the probabilities where I have been falsely implicated, and these are the probabilities that sir, I am not going to. Many people, in many cases, recovery basically the custody of the person has been given to recover either the weapon, recover the muddemal property, that is the
Documents.
documents, etc., and the material evidence of commission of an offense from the custody of the accused. But many a times we found that offense are basically in black and white. The things are not with the accused. The things are lying with some other government department. And without making the preliminary investigation, the police directly jump into conclusion and they want to arrest the accused for the reason based known to them. So if, to my limited knowledge, to approach the court for ABA, where you have got very good defense, it's the very first day you came to know about this. Because that is the time where the investigation officer normally do not carry a detailed investigation. And he doesn't have any material with him to put up before the court exactly what is the evidence against you.
Okay.
They are only having your role you allege against you. And you are having a very bright chances to secure bail.
Okay.
To my perception, once investigation started, an intelligence officer, police officer gathered some preliminary evidence against you, and then you are going before the honorable court of session or high court, there will be evidence against you, and you will having a less chance of getting anticipatory bail.
Okay.
So you must know when to approach, where to approach, and suppose there is delay caused by you approaching the court for making decision and then you should be in a position that majority of the investigation must have been completed.
Okay.
And then you are approaching, then you can say, sir, this is a major evidence against me, how I am required in custody in a particular crime.
Okay.
So these are the things required to be incorporated in ABA and to put it before the court, but to clear cut defense before the court in an area where police has got to overcome and manipulate their further investigation. We have found in many cases you should not give liberty to them, and you must secure something. And number two, first thing is that in case of alibi, when offense was committed, you are not present on the scene. So the law settled by Indian judiciary is, on the very first opportunity you are getting, either before police or the court, you must put up your alibi.
Okay.
You can't put alibi at later stage.
Okay.
By creating your supporting documents, supporting evidence, I was not present there. So that is also you can put up in ABA.
Okay.
But with restriction as settled by the apex court.
Okay.
Yes.
Okay. Now, sir, there is one more question which I want to ask, that whether the original complainant who has filed the FIR, whether he is entitled to intervene and argue in an ABA filed by the applicant accused.
Yeah. Under 438 of Criminal Procedure Code, the aggrieved person,
Okay.
the word is aggrieved person,
Okay.
can intervene at the time of hearing anticipatory bail application of an accused or applicant, and to put up his case and the evidence lying in his custody or the facts lying within his knowledge on oath before the court.
Okay.
He has got independent of PP.
Independent of PP.
Under 439, you have to go through PP. But under 438, you can file intervention application, because it also been revealed that when offence has been registered against the influenced person, despite of complainant have lodged his FIR in detail, police doesn't gather the evidence. Many times they very diplomatically hidden the fact before the court while filing their report against the ABA. And while reading the report, though they are incorporating one sentence that for further investigation we require the custody of accused. However, in detail in report, you will find that police have miserably failed to make out a case against the accused. That is an injustice caused to the complainant.
Okay.
Justice in India will cause to accused also and to complainant also. In this case, complainant has got right to either come in person or through his or her advocate to file their detailed intervention application. They are opposing the bail of the accused. On which ground, what are the evidence they have given to police, and what are the circumstances prevailing, and they can even put their written argument also.
Okay.
Before the session judge.
Okay.
So session judge will come to know, or High Court will come to know, okay, now it is his case in FIR, these are the evidence, these are the circumstances, these are the reason for rejecting the bail. However, the same thing has been suppressed by the police indirectly.
Correct.
So again, this is the things where aggrieved party, because see, you will appreciate, it is not a regular bail. It is a pre-arrest bail. Anticipating an apprehension of your arrest, you are asking special relief.
Correct.
And where you are making a false representation, or police will, to support you, police will bring dilemma report, or unbalanced report, vague report. At that time, if that anticipatory bail application will not be defended properly, will not or either opposed properly, the injustice will be caused either to accused or to complainant. So for right of complainant, it is necessary that complainant should be allowed with advocate, without advocate, to put up his case in writing, and to even put argument against the bail application in writing. And that is allowed in all the practice of all the courts.
Okay.
That is a practice.
Now, sir, I want to ask you one question. That can a amendment be done in an ABA?
See, amendment is a it's
It's a typical civil term.
but see, in commission of crime, the fertile brain of the culprit, it differs from person to person. To bring any amendment to protect the right of accused in a particular fact or scenario is very difficult.
Okay.
Very difficult. And therefore, court, even Law Commission, you will appreciate read the report, 41st report of Law Commission of India. They have specifically mentioned that we are not here to put our any suggestion to the concerned court, how to hear the bail application, what to be considered to grant bail, what not to be considered, because it differs from case to case. What they have to bring is only an amendment and a provision. Now, I think, if you want to carry out an amendment, the first amendment which is already in provision, but not been mandatory on session judge or even high court judge, that has to be brought strictly, that when I am apprehending an arrest, see, apprehension of arrest can be instant also.
Yes.
It cannot be days, 2 days, 3 days, 1 month. So on apprehension arrest, if I go before the Honorable Court of Session, file my application without serving it to the PP or IO, because if I serve them, they will come there.
Correct.
So without serving them, if I am able to make out my case at first instance, so this is the case, I am apprehension arrest and this is my defense. I think the Honorable Session Judge and High Court should grant at least limited protection of not to arrest or not to take coercive steps against the accused and issue notice to PP then and to IO for at least 7 days period.
Okay.
And this protection not to arrest will be only be affected for those 7 days, 8 days, 10 days. On the next date when either complainant or investigation officer or PP will come with their case, then court has got this privilege whether to continue with the that protection of 7 days or not, whether to modify, whether to amend, whether to improvise, whether to reject it.
Okay.
But to me, this very purpose I found in many session court, even at high court level also. Few high court judges are fantastic. They understand the importance of ABA. They understand the real danger of apprehension of arrest. So at least, they give some protection.
Okay.
And they know this protection is not on merit. It is to facilitate, to accuse to without getting arrested to put up his case very fairly. But many types session judge we found that after filing of ABA on first day, second day, third day, they don't grant you the interim relief. And I think strict law should be provided with amendment. A concerned session judge should either specifically say on very first date the case is not made out, hence I reject the interim relief. Or he should say the case is made out, I grant him the interim relief. But session judge should not say because I have not served notice to the police, I have not served notice on the PP, then I am not entitled for interim relief. That amendment is to bring with some action against such judicial official who doesn't understand the constitutional right of person, the rights of liberty, These rights have been frustrated. Why this ABA has been allowed by the Law Commission is to uphold the right of liberty.
Correct.
Now this right has been frustrated. Many a time I found, many session judges, what happened there? Notice sir केली का तुम्ही? हो. Report file करून द्या मग बघू. Why? If police are not coming with the report, if PP doesn't have anything to say, it means as on that particular day of my appearance, prosecution have nothing to say against me.
Correct.
Which normally we see in CPC, CRPC everywhere. And at least with not granting me a protection on merit, but at least granting me a protection to not to frustrate my rights of liberty. Because suppose meanwhile, you have not given me interim protection and I have been arrested, then my ABA will become infructuous.
Correct.
And therefore, first amendment which I am seeking is to make every person responsible liable, whether from judiciary, from police, from PP department, from anywhere. The rights of accused is having a rights of liberty under Indian Constitution for which this ABA has been brought, and therefore I am of the opinion there should be something to be taken in amendments and to make them responsible liable and taking action against them. You reject my interim. So once you reject my interim application, I am become entitled to approach the Honorable High Court under writ jurisdiction for particular period of protection.
Correct.
And even High Court should be given an amendment, these things, rights, that my bail regular application will be heard by the session judge. But the interim protection rejected to me by the session judge should be heard on the very first day, and even High Court should decide whether for 7 days, 8 days I should be protected or not, and remand back that, remand back me to session judge for hearing a full-fledged AB application on merit. But my right to be enlarged on either interim bail or interim protection should not be frustrated because of rigid approach of the judicial officer. That is my. by making this submission, I might have, displeased many of the judicial officer. But they should understand my perception. If
Correct.
suppose tomorrow they will be an accused and this same treatment will be given to them, they will understand the rights of liberty. Then they talk about the rights of liberty, rights of accused. But while they are sitting on dais, they don't think so. So my humble submission, they should consider at least on merit and at least on the in the light of Indian Constitution, that person should be given first interim protection, may not be on merit, but at least for 7 days, 10 days, so he can make preparation, he can argue and fight out the ABA.
Okay. Sir, now I want to ask you a question that is it necessary that the applicant accused who has filed the ABA, whether he has to be remain present for the hearing?
As such, there is no such provision in CRPC that one who is filing ABA, anticipatory bail application, must remain present. However, there is a provision in CRPC upon public prosecutor, police prosecutor, making a specific application before the court, that the final argument of this application to be made in the presence of accused, and therefore the presence of accused be compelled.
Okay.
In that case, the court will give direction to the applicant accused to remain present on the final hearing of the anticipatory bail application.
Okay.
However, I am again putting that, our fraternity is having a, fantastic lawyers. However, the court of this India, even High Court, even in Supreme Court, they have settled that before making such direction, the court must protect the right of applicant and to secure that he will not be arrested
When he is coming to court.
coming to the court, and therefore normally an intelligent advocate will always pray to the court that the final hearing will be on this day, so his arrest should be avoided till his subsequent day.
Okay.
So suppose today is the argument and the court have rejected ABA. However, he has been protected till tomorrow. So police cannot arrest him today.
Okay.
These kind of things can be done. Again, in our profession,
Okay.
the judges, if you are giving a good judges, they understand the severity, they secure the application of PP, the basic concept of hearing final argument in the presence of accused, but at the same time they understand the danger. If ABA will be rejected, he will be immediately arrested. And no court can become an instrument to effect the arrest of accused.
Okay.
Even you will appreciate the bail application cancelled or rejected by the High Court or Supreme Court. They give direction to the accused to surrender the police. They themselves does not make an instrument to make the arrest of the accused effective.
Okay.
Through them, they cannot make it effective. So this session judge must consider, the PP has made application, okay, I will direct. Today is our final argument, no doubt, but he will be protected without arrest till tomorrow. So today, even if bail application rejected in the court of session, court should not become an instrument to arrest the accused through police. That one we should appreciate that.
Okay.
But that is again, the advocate, it depends on advocate. Advocate should know the entire law. First, he should take, homework. He should do the homework. Various, relief granted by the Honorable Session Court and High Courts. Then he should go before the court and put up his case in a proper manner. Otherwise, this will be frustrated.
Okay. Now, since we are talking about this,
Sorry to interrupt you again. In connection with that, even my anticipatory bail has been rejected by the court. To approaching the higher court, the same court can grant you the protection of further 15 days or 10 days or 8 days not to arrest him.
okay.
This is not been written in provision, but settled position in the Indian courts. Sorry to disturb.
No, I want to ask you now, supposing anticipatory bail has been granted and maybe the complainant or maybe the prosecution
Yeah.
is not comfortable with that order for certain reasons
Yeah.
and they want to cancel that particular bail order,
Yeah,
ABA.
yeah,
So where they should go? The same judge, High Court, what is the process for that?
See, there are two things. If order was snatched by the accused by making false representation, then they can even approach the same court that after order was obtained on fraud and deception. But if order was passed on merit and they are not satisfied with the observation of the court, so in one condition that order become appealable and challengeable before the Honorable High Court. And if High Court has granted before the Supreme Court, that the order passed by the judge while granting ABA has not given any reason or a vague reason, or rather the reason given are self-contradictory. While allowing application, on one side court observe this and one side court observe this, so that is not possible. Such order becomes an appealable and challengeable before the upper court.
Upper court.
Not before the same court.
Okay. Now,
But that can be considered, and that has been considered by the Supreme Court also.
Okay.
And bails are means cancelled.
Okay.
Even though ABA order granted by Sessions or High Court was compliant, the accused was enlarged on bail by executing a PR bond, surety bond. All are cancelled
okay.
because the main order under which he has been released on bail was not tenable at law.
Okay.
Was frustrating the basic principles of law. Hence that order, but the application name will be setting aside the same order. It is not cancellation of bail.
Setting aside
the order. Like that.
Okay.
Yeah.
Now I want to ask this section 438 CRPC, that is anticipatory bail.
Yeah.
Whether it is applicable to entire India and in light of Article 370 being gone, whether applicable in Jammu and Kashmir also.
Now your question is having twofold. Number one, to my limited knowledge, I may be pardoned if I am wrong. The CRPC is not applicable in Nagaland
Okay.
and other tribal areas.
Okay.
They are having their own laws,
Okay.
local laws, as per they are dealing with, because they are having their own procedure of punishment and etc. and etc. Prior to this 2019, see, I am telling you apart. In 1976, the Uttar Pradesh have removed the provision of anticipatory bail application, though it is applicable in India, but not in Uttar Pradesh. After 43 years, it has been again reinstated.
Okay.
And now, that particular anticipatory bail under 438, you can approach the Uttar Pradesh Session Judge or High Court. But again, there are 4 kinds of offences for which this ABA is not allowed.
Okay.
First is the unlawful activities. Preventing Act 1967. The other act is the Narcotics, Drugs and Psychotropic Act, Substances Act. The third one is Official Special Act. And the fourth one is Uttar Pradesh Gangsters and Anti-Social Element Preventive Act. And another one is any offence punishable with death imprisonment. These are the offences where ABA is not provided in Uttar Pradesh. It is avoided in other states, but not in Uttar Pradesh.
Okay.
Right. Now I come to the Jammu and Kashmir. Now one disputed judgment is also given by the Karnataka High Court. A person coming in person or with advocate cannot apply for anticipatory bail. Some odd judgment is there. That I will come, I will on some other time I will discuss. But however, in Jammu and Kashmir, there was an act called Ranbir Penal Code. It was brought in 1932 in the regime of Maharaja Ranbir Singh. It was in force till 2019. Then it was repealed. As Article 370 was barring other laws of India to enforce in Jammu and Kashmir, now the central government, Parliament have removed 370. The best thing is that removing 370 of Indian Constitution, Article 370, and making Jammu, Kashmir, Ladakh become the part of Union Territory of India. Hence, other laws applicable like Indian Penal Code, Civil Procedure Code, People Representation Act, even Criminal Procedure Code will now applicable in Jammu and Kashmir.
Okay.
Now, how they have brought this? In 2019, they have bring Jammu and Kashmir Reorganization Act. Under that act, they have bring the Indian administration for this Union Territory, Pradesh, Jammu, Kashmir, Ladakh and all. So they have now reconstituted that.
Okay.
And under that reconstitution, these are now allowed. And now CRPC is enforceable in this Jammu and Kashmir. Hence 438 is also enforceable. And now the High Court of Jammu and Kashmir has also given one judgment that under 438 you first apply Session Court and then you come to High Court.
Okay.
So now again, now we can say that judiciary have also recognized this particular enforcement. Therefore, I have make this,
Okay.
So now this is applicable.
Okay.
But I am surprising in Nagaland and other tribal areas. Means what I have read that I am surprised. I may be corrected by somebody, but this is the things which I think to avoid this discrimination, the Indian government want to bring this,
Common civil
law. I think so.
Okay.
So there should not be out of caste, creed, tribal, religion, various states, language. There should be universal civil code. Fantastic thing, and to remove all the disputes. But
Today, what is, where is? Now we have discussed several aspects. I want to come to one last aspect of ABA, and that is transit anticipatory bail application. So, how is this transit bail application? What is this entire concept that I want to know?
basically, if person is residing in one state and by virtue of his official work or some other act, by making statement against the government or against any person, some case has been lodged, some FIR has been lodged, some riots have taken place because of my statements and FIR has been lodged in another state, then the very purpose of anticipatory bail will be frustrated if I'll travel to that particular state and apply for anticipatory bail in that state without having any protection.
Correct.
And therefore, under the same provision, same precedent, same procedure, I can go before the Court of Session or before the Court of High Court and make an application for transit anticipatory bail. Okay, look sir, I am residing in Mumbai. The FIR has been registered against me in Delhi. If I go to Delhi, the likelihood I am apprehending my arrest. So I may be protected to travel from Mumbai to Delhi. I will require 1 day, 2 day, 3 day that I have to make. By which route? Suppose I am a poor guy. I cannot travel by plane. I cannot travel by train, bus or car. So it will take me 2 days, 3 days to reach Delhi and to approach the Delhi Session Court or Delhi High Court. Till then I may be protected in case during transit from Mumbai to Delhi traveling, if my arrest will be caused and affected by the Delhi police, then I should be immediately released on bail
Okay.
at the place where I have been arrested.
Okay.
You know, in transit bail,
Correct.
that is called. So, that is only possible if I am able to, show my some of my, role in the particular things and show my genuineness. Now, basic concept of ABA is that the, proclaim offender cannot seek ABA. That is not allowed. Even absconder, declare absconder by court or by any specific authority doesn't normally come. Nowadays it happens that the person who is residing in other countries, offensive registered here, he can approach through his embassy, give instruction to the local lawyer, send his affidavit, seek protection and then come to India.
Okay.
But in transit, this man, that is across country. And this is across state.
Okay.
You can apply for transit bail, but for a particular period, after the 3 days, 2 days period mentioned is over, your transit bail is gone.
Okay.
Then second transit bail doesn't allow you,
Okay.
because you have to comply with that order by starting your journey as you have represented to the session judge, local session judge, and you have to complete your journey within that period.
So Desai sir,
Yeah.
thank you very much.
Oh, no, I should tell you thank you, sir.
And as a token from Hammurabi,
Ha.
this is a small token for you.
No, thank you very much. I must tell you thank you for a reason
Yeah.
that I have been invited on the Golden Jubilee era, on the 50th
50th
episode, right?
50th episode.
So this privilege you have given to me.
My
And therefore, sir, I am honored, sir.
Thank you.
Thank you very much, sir. Thank you very much. Thank you.